And these are really the three keys to whether or not you're going to be able to get a patent. I've even worked with a couple of you on doing some searching, and most of the searching falls under this non-obvious or novelty category, but the three prongs are, it has to be useful, and you can argue that just about anything is useful. It has to be novel, that is, not already invented, and it has to be non-obvious. And this is the prong, this third prong is the one that trips most people up, because I think it's much easier in retrospect for a patent examiner to say something is obvious once they've seen what you've invented and they see what was before you and they can see the natural step. The test is supposed to be for one of ordinary skill in the art at the time you made your invention, but it's hard to put yourself back in time to that period. And so in prosecuting patents and in litigating patents, this is the prong that trips the most people up, is the non-obvious. And when you are trying to decide if you've come up with something that's not obvious, it's very difficult to do, to look at the body of inventions and work that's already out there at the time and decide if it would have been obvious to a person to make the incremental improvement that you've made. So I can't really give you much advice if you're looking at this to try to decide, but since the test is one of ordinary skill in the art, is ask other people perhaps that are working in the same field and see if it's something that they would have thought was obvious to try. And the test for this is changing. The law has really changed over the last few years about what is and is not obvious. There's been another case called KSR that went to the Supreme Court. And the test used to be, was it obvious to try? And it's really evolved, and it's multi-pronged now. So if anybody's really interested in that, I can run through that with you. But otherwise, I'll just move on.